Um, Rule 132, Presentation of Evidence. Section 1, Examination of Witnesses. Examination to be done in open court. The examination of witnesses presented in a trial or hearing shall be done in open court and under oath of or affirmation unless the witness is incapacitated to speak or the question calls for a different mode of answer. The answer of the witness shall be given orally. Section 2, Proceeding to be recorded. The entire proceedings of a trial or hearing, including the question propounded to a witness and his or her answers thereto, and the statements made by the judge or any of the parties' counsel or witnesses with reference to the judge or shall be recorded by means of shorthand or stereotype or by other means of recording found suitable by the court. A transcript of the record of the proceeding made by the official stereographer, stereotypist, or recorder and certified as correct by him or her shall be deemed prima facie a correct statement of such proceedings. Section 3, Rights and Obligation of a Witness. A witness must answer question, although his or her answer may tend to establish a claim against him or her. However, it is the right of a witness to be protected from irrelevant, improper, or insulting question and from harsh or insulting demeanor, not to be detained longer than the interest of justice require, not to be examined except only as to matter pertinent to the issue, not to give an answer which will tend to subject him or her to a penalty for an offense unless otherwise provided by law, not to give answer which will tend to degrade his or her reputation unless it be to the very fact at issue or to a fact from which the fact issue would be presumed that a witness must answer to the fact of his or her previous final conviction for an offense. Section 4, Order in the examination of an individual witness. The order in which an individual witness may be examined as it follows. Direct examination by the proponent, cross-examination by the opponent, redirect examination by the proponent, recross-examination by the opponent. Section 5, direct examination. Direct examination is the examination in chief of a witness by the party presenting him or her on the facts relevant to the issue. Rule 133. Weight and sufficiency of evidence. Section 1. Preponderance of evidence how determined. In civil case by preponderance of evidence. In civil cases, the party having burden of proof must establish his or her case by preponderance of evidence in determining where the abundance of superior weight of evidence on the issue involved lies. The court may consider all the facts and circumstances of the case, the witnesses' manner of verifying their intelligence, their means and opportunity of knowing the facts to which they are improbability of their testimony, their interest or want of interest, and appear upon the trial. The court may also consider the number of witness, though the preponderance is not necessarily with the greatest number. Section 2. Proof beyond reasonable doubt. In a criminal case, the accused is entitled to an acquittal unless his or her guilt is shown beyond reasonable doubt. Proof beyond reasonable doubt does not mean such a degree of proof as excluding possibility of error produces absolute certainty, moral certainty only is required, or that degree of proof which produces conviction in an unprejudiced mind. Section 3. Extrajudicial confession. Not sufficient ground for conviction in extrajudicial confession made by an accused shall not be sufficient ground for conviction unless corroborated by evidence or corpus delicti.